good morning, everybody. Welcome to Cannabis Live. I'm Craig Aronoff, along with my colleague Travis Copenhaver.
Morning.
We're here to talk about all things to do with Michigan's Medical Marijuana Facility Licensing Act and our new medical marijuana market that is reaching a big day in our time horizon today.
Yeah, happy December 15th, everyone.
Yeah, we've all been waiting a long time for this. We're thrilled to be able to talk to you today and discuss things that are actual, things we've been waiting on. We got a rule set. We got an application. We actually got an instruction book from the state. Before we get too far into it, please remember we're from the Cannabis Legal Group in Royal Oak, Michigan. You can find us at cannabis-legal-group.com. For those of you still looking for properties throughout the state, we encourage you to check out our website at cannabis-legal-group.com/municipalities. We are still tracking lots of different communities throughout the state of Michigan. We're going to talk a little bit about, what's happened recently, what we can expect here coming up over the first quarter. And I think that page is going to fill out considerably differently over the first quarter than it has right now. But please use that resource and certainly participate in that. If you know of anything that's not there, please let us know. Similarly, if you're interested in engaging the industry, we are collecting resumes. We are starting to hear from applicants that will be putting in their licensing very soon, asking for resumes. We've collected a number of them. If you're out there and thinking you want to join the industry, you can go to cannabislegalgroup.com/cannabis-jobs. We'll be happy to accept your resume and forward those on to people who are interested. Beyond that, I guess we're going to dig right in. Last thing, please like us, share us, show your support. If you have questions today, please feel free to ask them. We're going to do our best to answer them as we go. There's a lot of detail in these rules. A lot of people have a number of different questions about it. We'll do our best to kind of hit some topics, but if there's a portion of it that you're very interested in, please, by all means, ask that question. We'll do our best to answer it either live during the show or in follow-up through private messaging. So
Definitely.
I guess with that in mind, where do people go to find these rules?
Yeah, so both the rules, a copy of the application, and then information packet called the instructions for that application are all available at michigan.gov/medical marijuana, spelled with an H. You can go on there, you can start reading through them. They list out, everything is going to appear not only on, the electronic version of this application that should be available anytime today if it's not out already, but you can start reading through, and there's instructions for how to fill out those forms accurately, what those documents and pieces of evidence need to be. Probably not as thorough as it could be in some places, but certainly give you an idea of how to get started and what you need to do to put one of these projects together.
Yeah, absolutely. And, and while I think that, people have expected, a certain amount of perfection through it all, we must compliment the way the state has gone about doing this. Our colleagues from Vicente Cedarburg were in town with us last week. We had a fantastic seminar. We look forward to another one coming up in February, which we'll announce in the future. But, what was really interesting was the actual application itself came out shortly after the rules, but it came out while they were in town, so we really got to dig in and talk to them with their experience in being in Colorado and having been involved in these regulatory, environments in other states. They were really impressed with how our state has really gone to best practices within all the operating states and really kind of honed in. Although it's a 33-page set of rules, it's really designed around best practices to help us get going, and that rule set is going to fill out.
Definitely. And I think when you look at it from a more national perspective, they were very impressed with the amount of work that our Bummer Board and the law administration put into putting this all together in a short time frame. They really did see a lot of those items that kind of got workshopped in some of the other medical marijuana states throughout the country. And, they were quite impressed by how fleshed out and thorough it was, even in its emergency rule form. We certainly probably have room for improvement. We're probably going to learn a lot of things as we go, and as this board and as Laura, really starts digging its teeth into this. But from both our perspective and our partners at Vicente Cedarburg, they definitely have a good foundation to start with.
Yeah, no doubt about it. And and as we went through the rules, and what we're going to do today, I think, is kind of leave it as basically a free throw of thought as we go through it. As much as we tried to kind of hone in on specifics, it's so much in so much detail.
Sure.
But what we'll kind of do is walk through the application, and what I think what's going to happen is it's going to lean into the instruction book, and then of course the rule set that overlays through this entire thing. I think on the onset though, a couple of caveats that we should throw into this. First and foremost, and we've said it for some time, but it's really proving itself to be very true now, is that this is an emergency set of rules. This isn't the end-all, be-all of where we will be. This is simply the base in the beginning. And so if it's what we need to get you licensed, that's great. But it might not be what we need to keep you licensed.
Certainly.
And so as you begin to operate, and as you begin to actually take on the industry as an operating licensee, we best be paying attention to how these regulations are going to be made more robust, we'll say. And our goal as a company here at the Cannabis Legal Group, along with our partners at Vincente's office, is to really focus in on making sure people will be operating at a level to keep their licenses. When the state's asking next year, tell us how you operated. This year, it's tell us what you plan to do. And so that's one caveat. And I think another is something Travis and I were talking about in advance of today's show is, basically accuracy.
Certainly. Yeah, because a lot of people, the 15th has been a big day, a big target for a lot of people interested in this. And it's important to remember that, this is not a deadline by any means. Everything that's going into this application, both in your pre-qualification, step 1, and in the step 2 when you're talking about the license itself and how you're going to operate, it's all about giving the state enough information so that they can confirm you're capable and you're responsible enough to run one of these licenses. If you rush as fast as you can, even if you successfully get a license, you're going to be held to what you assert to the state that you're going to do in your employment plan, in your technology plan, in your business plan, in everything you commit to in this application. If you go out there and when you have that license in your hand, start deviating from the course, that's going to give them cause to investigate what you're doing, and you put yourself at risk, knowing that these rules are only emergency rules. It's a pretty minimum set of standards right now, and you should be expected to operate above and beyond what those minimum requirements are going to be. And if you put yourself in a position to not only, flirt with how close you're getting to the emergency rule limitations, but also start moving beyond the types of, statements and commitments you're making to the state, you're not doing yourself any service. So, rushing to getting a license put together as quickly as possible just so you can get that license in your hands. Sure, the sooner you operate, the sooner you can start, making this license, making revenue and getting products on store shelves and things. That's all very important. But you don't want to put yourself, you don't want to shoot yourself in the foot. You want to make sure you're doing this as accurately as possible. And in most cases, if you do take the time to do it right, you'll probably get through this process faster than getting something on to them quickly. Because once it's in their hands, then they know exactly what you said.
That was funny. We would not have expected that. If anyone knows them, we would not have expected that. No, you know what? Listen, I couldn't concur more. As we really dig into this, rushing into this just to say you got your application in doesn't necessarily mean that's going to be reviewed first. It doesn't mean that you're going to come out ahead. It doesn't mean that you won't be faced with some questions about that particular rushed package that you might otherwise avoid if you just patiently put it in the right way. And I think that's really the counsel that we're looking at. This is day one. It's not a deadline day. I know a few people felt a lot of pressure and urgency to get it in there. The state's going to go through the process, and what they're going to do is review people who have a complete package. We have 2 sets of checklists, really 3 if we include the supplemental applicants as well. And so, step 1 is for the applicant and all supplemental applicants. And the information requested and the detail requested and the collection of information that you're going to be required to provide should be done patiently and properly. And when it is complete and proper, that review package will make its way through more efficiently than those who think that by putting in partial information just to get it loaded in that they can supplement later, you're doing a disservice to yourself if that's your goal. In addition, I think that there's been some, as we go through this information, people that might be trying to hide within the layers of onions about different true parties of interest and this and that. It is very, very clear through this disclosure within both the application as well as in the instruction book that they are digging down to the individuals, people. They want to see human beings as part of this supplemental package. So you can have 9 LLCs layered in together that are all designed to own one another and trying to play the anonymity of guess who is the owner. This rule set and this application is going to tolerate that.
Mm-hmm.
And to the extent that you might be trying to, and again, if you're working with us, that's something we're going to be counseling against. But for those of you who might be thinking of it that way, where we'll just start with these 3 people and we'll figure out who our manager employees are later. Keep in mind when you're giving your staffing plan in phase 2, you're identifying that you're going to have managing employees who should have been actually vetted in step 1.
And the application and law is putting the burden on the applicant to identify not only who has ownership, direct or indirect ownership, but also who has control, direct or indirect control. And you might not know who those people are yet. I mean, and that's okay to get started when you're putting these together. But keep in mind when you get to that step 2, which needs to happen before they put a license in your hands, you're going to identify employees, you're going to identify potentially managers and people with control, whether they're technically employees or not of your company, or technically owners or not. And if those roles are identified, and once they start being filled, if the statute, if the rules, if the application requires them to be evaluated and submit these types of documents and evidence, then you're going to have to do that before your final license is issued. So, pre-qualification, if that's the step you're at right now, is certainly something you can take advantage of. The application process is open. We don't know how quickly you'll get answers back, but there's probably a lot of use there. But that doesn't mean if you get pre-qualified today and you take 6 months putting everything together, when you go get those employees and start filling those roles, filling those contractor agreements or HR management companies, other parties might need to be evaluated as well. So pre-qualification today doesn't necessarily mean qualified a month from now or 2 months from now.
Yeah, I think that there's no question that there's an ongoing duty to supplement.
Mm-hmm.
It's effectively written into the rules that way. It's written into the application process that way. And just to kind of hone in on just kind of, as we said, we're just going to pick out a nugget here and there to talk about. But I want to kind of layer in what we're getting at. We're talking about 2-party of interest. In particular, what we'll be talking about is disclosure 2C, or what would be 2CSA if you're a supplemental applicant. And looking at the instruction book, a lot of people thought, well, I'm going to own the real estate, and that's going to be my interest in this, and I'm just going to get a fixed rent price per month, but I'm going to retain control over the premises, and I'm actually going to be the one managing the facility, but I'm going to get a high, rent price for that, rather than just being a passive landlord, which would be the normal lease situation. Right. Or alternatively, maybe they're a HR company that is, contracted to provide, employees who retain management control for a fee. And so these are not people that are necessarily expecting a percentage of success. We know that if you're expecting to gain as a result of the success of the company, that's clearly an identified true party of interest. That's easy. Mm-hmm. But this is something that's ancillary. It's an indirect benefit. You're operating, you're getting paid a lease, it's a fixed price. And what this says is that a true party is not a person receiving rents on a fixed basis, unless the lessor or property manager exercises control over or participates in management of the applicant's business, control over or participates in the management. That's a wrinkle, and that's something that a lot of people are looking at. Well, if I'm not eligible to be vetted, how can I still participate in this and still gain, maybe by not giving up my position as a manager, and eventually that'll convert into some ownership equity, rather than it just being a pure natural lease. And the rules make quite clear that that person should be identified and vetted as a true party of interest. And so, again, that's just one little nugget. And there's many of these little nuggets throughout this rule set.
In a similar vein, we know that a managerial employee is going to have to be vetted. But what if you conceptualize someone in a similar position as just an employee? Well, they make clear, you can give an employee a bonus, but the minute you give more than 25% of your annual fixed wage or salary in a bonus, that person needs to be vetted as well. And you might not even know that today. You might think, okay, we're certainly going to treat this person as an employee, but as you operate for a year and you do well and you start making money, maybe you forgot that was a requirement, and he had some questionable past or history for financial reasons or criminal reasons, and that's why he was an employee and not something else. The minute you provide him with a salary like that and the state becomes aware of it, you might, even post obtaining your license when you come to your renewal or when you come to some other, inspection or something, need to, go through the supplemental vetting now because of the salary you pay this person. So, whether or not you obtain a license doesn't make any of these factors go away. You can't just get your license and go out there and operate not paying attention to these restrictions that were put in place. So, whether or not in a, employee staffing plan, you conceptualize bonuses or not. Well, in reality, the minute you issue one to an employee, if you do so, frivolously or, without being focused on the rules, you might draw that person right into a vetting process that you were trying to avoid. So,
and where it'll come up, of course, is when they're reviewing your application year 2 and they see that this funds were paid out. So again, it might not be getting your license that raises this. It might be simply later on next year, they're looking at how your distributions occurred. You had that contracted or salaried employee at $100,000. They've been doing a great job for you. Maybe their title is master grower or facilities manager, and they have a fixed salary, but they got a $50,000 bonus, or maybe they got a $26,000, or maybe even a $25,001 bonus, because that would be a 25% margin. And so now all of a sudden that payout is something that your tax returns will reflect as an operating entity. That's something that your financials will reflect, and I think it's fair to expect that year 2, when they're going through this, this application process to continue, that's where some of those identified parties would have to go back through, and hopefully, conduct and good wage and doing things correct might be the reason that this discretionary opportunity of the board to deny people would be resolved. And so, doing good work could go a long way as well. So we mentioned that there's 3 different, effectively checklists. So there's the applicant checklist, which is at the top of the application, and we have phase 1 for that. And if you're the applicant, which could be the individual or entity, it's the entity itself. And so this is the entity disclosing all the people that might have an interest in it, as well as all the financial monies for coming into the entity. And so the attestation will be involving the entity. The supplemental application checklist, which mirrors almost identical to the applicant checklist, are the individual members of that entity that would be then providing their own personal financial statements, as well as any attestation of the monies they're bringing to capitalize the business. And so if we can just kind of jump into the CPA attestation, that seems to be a question that we're getting a lot of. I think it's maybe easily said that it was a very confusing and ambiguous thing. We were hoping maybe there was a form that they wanted, and with the CPAs, if anyone knows any CPAs, and this is, I guess it's a little stereotypical, but it's half joking, but they're very much follow the rules, and we need a bucket, give us a form, we'll fill out the form, we know what we're doing within it.
And just to answer the chat real quick, we are attorneys, and we would be happy to take questions, but so feel free to put them in the chat if you have them.
Yeah, absolutely. It's just timing and all that, and we want to be efficient with it. But as it relates to going back to the CPA attestation, so when we go through the actual book itself and on the instructions, what we find is the CPA attestation that really lays out, and it's in Disclosure 3A, it would be EIPP 15 on page 20 of the instruction book. And it says the CPA attested financial statement, kind of including a form attestation, documenting the sources and total amount of applicants' capitalization to operate and maintain proposed marijuana facility. Now, a lot of people have been asking, well, do we need a full financial attestation, a full financial statement? Or we really only need what it says, which is a CPA attestation to the funds being sourced for purposes of the operation. And so, again, that's something as we sit down with CPAs, and, we have one here, Simon Guma, who will be working with us here at the Cannabis Legal Group. We've already spent a lot of time talking about what we believe and understand this to mean and what the formula will look like and all those kind of things. But CPAs that are maybe not as in tune with it and are being asked by their clients now, hey, look at this, I need you to sign off on my capitalization. They look at it like the state's asking us to audit your financials. or do a full-blown financial statement, quote unquote, on your entire financials. And I think as we, reasonably look at what that rule says, especially in the instruction where it laid it out a little bit more clearly, it does says documenting the sources and total amount to capitalize the entity. Mm-hmm. And so again, if we were just trying to understand what the purpose is to say that if you're trying to show you have $300,000 available in capitalization for your processing license, that somebody didn't give it to you yesterday and that you put it on an account yesterday, and they, hey, look, I got a statement, I got $300,000. Well, never mind that person provided untaxed, ineligible money and deposited into your account. Right. You're going to need to source that back three years, so that at least it makes sense how you got it. I had a transaction. I sold a building. I sold a company. I made $5,000 a month over the last 60 months. Whatever the reason is, it added up to $300,000. It needs to be there somewhere.
And it's something to keep in mind as well, is even if you were fortunate enough to have that happen beyond 3 years, and it wouldn't necessarily show up, they reserve the right to seek additional information on any of these attestations, on any of these documents. So, if you have things structured in a way where, sure, in a 3-year time frame, that's not going to be a factor, but it still raises questions, those things might still be something they follow up on and want to learn more about and might ask you questions about.
That's right.
Even if your sources are 100% legitimate, and if they don't look that way or they have questions about it, you might still be expected to explain yourself or explain where those fundings came from. So, just because application is thorough, it's about 42 pages, I believe, or 50. So, several, probably what's going to result in hundreds of pieces of evidence you're presenting to the state. That's your original, submission. It doesn't mean you won't be expected to provide even more information when the state starts reviewing it. And we'll have a little more feel about what the time frame it's going to take, what kind of follow-up questions to expect from them. But they're learning how to do this as well. I mean, maybe some applications have been submitted already, but they haven't reviewed any of them yet. So once they do start getting, some feedback back, we'll all be a little more informed about what this process is going to act like once things are turned in. But all we can really do day one is, collect this information, upload it to the online application, and wait and see what the state does with it.
Yeah, and I think that that's a very important point, and one that can't be, I think, ignored through this, is that this board, as much as they've done the work to try to understand exactly how they're going to operate this new licensing law, has not yet made a single decision. Mm-hmm. The Bureau itself has not yet actually reviewed an application. And so those two actions that are things that are not yet known also leave open the realm of all the different ways that could potentially answer it. And so a lot of people will ask us, well, I had a bankruptcy like 8 years ago. What will they do with that? Mm-hmm. Truthfully, we need to have a set of facts where we can look at next year and say, we had like 7 clients who were in a similar situation, and this is how the board reacted. We'd have a set pattern, and these lawyers like to at least look at precedent, right, and talk about how past actions could provide for reliance in the future. We're not quite there, but we're getting there. So a lot of this is making presumption based upon experience, and also, of course, relying on experience from our partners, in Colorado that, have seen actions from similar boards in similar situations, and kind of going through and allowing us to really upstart and uplearn that. Just keep that in mind. So we have to leave the room for flexibility, and that gets back to accuracy. That gets back to not trying to cut corners. That gets back to not trying to play your way through this. That's the state is looking for reasons to tell people no, right? The easy answer for them is to say no for any reason they can. And so, if people ask us, well, how will they, they can limit licenses? No, they've actually said if you do what you're supposed to do and you put it all in there, they should just give you the license. Mm-hmm. The problem is if you do it half-assedly and or in a way that appears to be coy, where you're trying to hide something, they're going to see that.
Right.
And I think that that's the kind of thing that's going to raise that scrutiny level and probably will result in a denial.
Certainly. So we can dive into some of the specifics, and I know we have a question about like real estate, for example. Well, we can go right into the real estate section here if Craig gets a chance to look at it, which I believe is on page 16 of the application, real property interest. And basically what it says, if you want to...
Yeah, I mean, the question is can you list it all out to justify the assets needed to operate? Now, keep in mind that, you know, the real estate itself is a component of it. So first and foremost, we know 25% of the source of funding for the capitalization must be in cash rates equivalent. So real estate doesn't qualify for that. So this only qualifies for the 75%. Now, this is as it relates to the operation. So if you have unrelated real estate that might have equity in it, that could be a source of getting a loan or, you know, some kind of you know, a credit line or something that you can maybe draw that off of and turn that and convert it into cash. But when it's asking about what you're intending to do to operate, really where they're asking is I already bought that parcel. It's got a, you know, it's a 10,000 square foot building, industrial zone. I plan on going for a Class B license. I paid $125,000 for the building. Now, and it's owned, that's $125,000 of value towards your capitalization because that's a source intended to be used in the operation.
And that's where the CPA steps in to, you know, certify that that is a correct and accurate, you know, estimate of the value of that asset. But let's assume, Patrick, that you want a Class C grow. Class C grow is required to have $500,000 in capitalization. 25% of it needs to be liquid. So you can use your, you know, several commercial real estate properties and then figure out the value of each of them to start adding that up. But that still means $125,000 needs to be in cash or in bonds or in stocks or in retirement funds or something liquid that you can also have as capitalization. You can have $8 million in real estate, but if none of it's liquid, then you still are missing a piece of that capitalization requirement.
That's right. And of course, just to kind of split the hair, we're talking two different things here right now. We're talking about what this disclosure is going to require. First is the funds to be used for capitalization. This is what we're demonstrating, that we have the capital to invest in the business for purposes of thereafter operating, and these funds are allocated for it. And so if it's already been invested in real estate, we don't lose that liquidity because it's been invested in that real estate. We just get the value of it against the 75% non-liquid component. On the other hand, the questions within the financial disclosures are still asking for the applicant's other assets. So separate from the capitalization component, they're still looking to see the financial health of each individual applicant through this. So they're going to be asking you to disclose your assets. Now, one of your assets might be a member's interest in an LLC that owns other real estate. And if it's beneficial to demonstrate your financial health by disclosing those interests, which of course it's asking you, basically forcing you to do through a notarized document, there's no reason not to disclose it. Now, it might not actually be used to source the capital, but again, it's showing your financial health and that you're not somehow somebody that would be in questionable financial position that could be compromised. And that's what they're worried about, is people that have a lot of debts might look to do things to maybe offset that debt questionably. And that's why there's still a discretionary component within this entire licensing board.
Right.
And so, Patrick, hopefully we answered your question, and it did allow us to discuss how, you know, the capitalization and other assets can.
That's really a good point, because, you know, will you have to list all of those properties? Well, that depends. Well, who's the applicant for this license? Is a LLC that owns, let's say, 100 commercial licenses out there seeking a medical marijuana license? Then yes, you will have to list everything and anything, because that applicant owns financial assets. Now, if it's a member, let's say somebody with 10% stake in the LLC that's going to seek the state license for a medical marijuana facility, and that person happens to have interest in a different LLC that has hundreds of commercial real estate property, well, then it becomes a question of, you have to meet the financial disclosures available, but do you necessarily need to go past, how much money you have in, those assets held by a separate LLC? You might want to, if you need to demonstrate the financial health of that member with 10% interest, but you might not necessarily have to do more than value the LLC itself that you also might happen to have ownership in. So depending on the position of where those assets are, who owns them, and then what corporate entity is seeking the license itself, you probably don't necessarily need to list every possible asset any one of your owners possibly has ownership in. But there might be reason to demonstrate that depending on how close to the heart that person's position is in this overall project.
Yeah, I mean, and it's as far as the supplemental application goes, it is, they want to see all the real estate property interests that the supplemental applicant has. And if we really kind of dig in and look at like why do they need to know these type of things, first and foremost, if we were trying to obtain a commercial mortgage and we were trying to then get, let's say we want to finance our building here at 520 North Main. The bank is going to go through a certain set of due diligence that's going to look at our financial health for the likelihood of us acting as a good actor as their borrower. And so that kind of mortgage application process, these disclosures are very commonplace. This is what you do when you're trying to demonstrate your financial health to the financial institution. So what they're asking for is really not outrageous, nor is it anything we wouldn't have expected. But as people are trying to, maybe play a little bit of a shell game, they want to be anonymous in this, or, they don't want their other partners in a different entity to know that they are actually involved in the industry. Now, they might not find out about it, but you still have to disclose it. And so, as we compare what this process looks like, and I mentioned, the mortgage industry, on the flip side of that, if you're trying to even negotiate the debt away, they similarly want to look at your financial health. And so all the state is doing is really kind of doing that background check. We want to make sure people don't have a criminal background history. That's a disclosure form that's on here. We want to make sure they don't have a long litigation history. That's another disclosure form that's on here. So we're giving out the public information regarding, both our past practices from criminality as well as from from a litigation standpoint. And if I can dovetail real quick, criminal history, we get a lot of questions about that. I had an MIP when I was in college. Well, how long ago was that? What have you done since? And so thank you for the note, Benjamin. We'll do our best. We don't know how we sound on the other side, so if we did come in a little light, we appreciate that. And Rick makes a great point. Failure to disclose some will absolutely lead to a rejection of the application or the loss of a license in the future. And so, in that vein, again, transparency is very important. So this is a time where maybe actually providing more information and giving the full disclosure rather than trying to decide what you should disclose is going to come out to be more beneficial to you.
And 2 or 3 years from now, we might have an idea of what becomes redundant or unnecessary. But in day one, in these first few weeks before we start getting decisions made, based on the way they've laid out this application, it's going to be better to assume they want everything and anything and not try to hide anything. Because even if you innocently leave something out, and that might raise questions for the state, and they might start going down a path of investigation that might, maybe do little more than delay getting your license, but, a delay might keep you from opening for several months if they have to go vet out that, thought they might have because something was innocently, accidentally left out.
I like your joke, Rick. Be honest with your lawyers. Always.
Exactly. Yeah.
Thank you for that. You know what? And just as we're talking about, looking at the attestations and the supplementals, one of the early attestation forms is actually giving the state the right to do its background check on you. And so they can actually, if anyone's seen what a credit report looks like, from a computer, somebody can log in using a service that aggregates data and all of that. Literally by nothing more than your name, your authorization, and your social security number, literally pull up your entire financial history. Well, private investigators in the service that we're going to be using for this background check can similarly use a few data points, name, address, social security number, and literally pull up your entire history as it relates to things like your cars that you've owned, phone numbers you've had, addresses you've lived at, ownership interests you've had, public disclosures for cases that might be pending in courts around the country. And so the attestation form is your way of saying, here's the information I'm feeding you. And they're going to be cross-referencing that against something that might be looking to see if you failed to disclose something. Now, it might be inadvertent. They might come back and say, hey, what about that, that civil case that was pending in Macomb County in 1999 that you failed to mention? That seems like a reasonable question to come back. But if they come back thinking that you intentionally hid that felony that you got set aside that you failed to mention that trafficking case that you were involved in 2004, more than 10 years ago, but still on your criminal history. That might cause them to say you did it intentionally because you're trying to hide something that could be suspect rather than say, hey, that happened. I was in the wrong place, wrong time. It was dropped because of these following reasons. Again, just keep in mind the board is going to have independent information that it will be holding against the disclosure forms we're providing. And if we don't think they're going to be cross-referencing that, again, we can't be naive to go through this. They're looking for reasons to catch people and say no. They're not going to put a lot of energy to it, but they're happy to find it and just deny it, I bet. So just kind of thinking in terms of how other licensing goes and stuff like that.
You want me to hit Benjamin real quick here?
Yeah.
So this kind of goes away from applications, so I'll just do it quickly. So you can remain a patient and a caregiver under the 2008 Michigan Medical Marijuana Act. This is a separate, new statute, new license for a new type of business, still involving medical marijuana. Some of the licenses, growers, processors, secure transporters, do impact your ability to be a caregiver. Processors and growers require someone to be part of the applicant's team, whether an owner or an employee, with 2 years of experience in order to actually qualify for a license. Once that license is rewarded, you have to stop being a caregiver. They don't want you to be cultivating marijuana unregulated privately and then in a commercial system. And then for a secure transporter, they don't want you to be a caregiver, so you're prohibited from being a secure transport license if you're a caregiver. But if you will remain being a caregiver and being a part of a provisioning center, in theory you could. Now these new laws, these new rules don't really change the 2008 Medical Marijuana Act at all. But what you're going to see is the economics behind what the current system is should start shifting into this new system. So you'll see change from the day-to-day operation of what caregivers have been doing. But from a legal perspective, no law has changed to limit or prohibit caregivers from doing anything they're legally allowed to do today. Yeah. That's the key term, unfortunately.
Yeah, absolutely. And I think that we're even seeing that in some of the temporary operation language through the rule set that would allow a facility that's ongoing to remain within the MMA structure. And so, for if they have a caregiver center or whatnot, continue to operate not as an MMFLA, not as a facility licensee, but as an MMMA caregiver center. And so we got to stay within the restraints of that up until that license converts to a facility license. The only other thing about caregivers, if I may, is that there's still going to be a role for people who need help getting medicine from a provisioning center. So a registered caregiver could potentially be the delivery service for their patients, even if they're not necessarily cultivating it like they were in the past. They very well could be the person that helps get 30 miles to the dispensary to pick up that medicine. And also provide some consultation for the patient, learn which medicines that are now going to be hitting Michigan's market that don't yet exist. I think that's one of the things we're most excited about is to see the elevation and maturity of our medicine for, access, and then bring that back to their patient, go learn, and then, come back and talk about new tinctures and new oils and new forms of medicine that might provide medicinal benefits that weren't previously available. And so, it's exciting. I think it's a topic we could probably spend sitting here all day.
Certainly, yeah. I tried to keep it short, but it's hard to keep it short. So.
Yeah, we know this is one of our longer posts. Hopefully there's a lot of gems and nuggets for everybody as they look through it. We're going to be, signing people up through phase 1 here very soon. We do also have a few clients that will be fortunate enough to get through phase 2 in the very near future. We'll look forward to seeing how the board reacts to things and how this application actually comes to life from the paper and the online form. And so we'll be talking very much about it, a lot of changes, anything you see. Reach out to us if you have any questions, email us through Facebook or find us at cannabis-legal-group.com. And, until the next time, for Craig Aronoff.
Travis Copenhagen.
Yeah, we'll see you next time. Thank you for watching.
See you guys.
Bye-bye.